So James, I don't know quite what your plans were or are in terms of timing. We thought it would be important just for to mark it down. You leave Miss Knights and Mr. Squires enough time to reply this afternoon.
Yes, of course.
So were you aiming for about 3:30
I
thereabouts?
was, possibly a bit before.
Perfect. And then I think what we might do again, so you all know, is have a 5-minute break after you've concluded your submissions before we go into reply. Is that all right? Very good. Thank you.
That is, my lord. I was going to go to material consideration public law, and there really isn't that much more to say about that. We can canvass the basis on which it's now put and directly responded to that and on Article 4. Perhaps the important, or the most important point, and I'm not excluding its importance for the purpose of Article 4 as well, but the most important point for public law purposes it is that the material consideration question as a matter of domestic law would plainly fall to be judged in the context of Section 40 and what it was designed to do, what its basic nature was, and what the test it is requiring to be surmounted, conducive to the public good or national security threat. And for all the reasons I gave earlier, it is important we submit to recognise that is a power which Parliament intended should be centrally focused on the risk to national security. I made all the points I made earlier about why trafficking is not a necessary correlative of that, and indeed might well skew the analysis in a deeply unfortunate way that Parliament could not possibly have intended if you were required to use the lens of trafficking in its more or less extreme forms, as it were, precisely how the argument is pitched. And this is well to bear in mind under our domestic law, when that is the focus, what the Secretary of State is not deciding. The Secretary of State is not deciding whether or not to refer an individual to the NRM or to determine particular aspects of particular policies, not considering appropriateness of support under the NRM policies, no question of a continuing risk within the United Kingdom. So we do submit that context, that Section 40 context, critically shapes what would or would not be treated as being a mandatory relevant consideration. There's obviously no mandatory relevant consideration within the scheme or expressly within the scheme of the legislation itself, so it would only have to be obviously material. But that takes its shape from the context we submit. My learned friend then says, well, there are two basic reasons why there would be a requirement to consider, as it's put in paragraph 33 of our skeleton, whether or not Miss Begum is a victim of trafficking. And first she says that consideration of her status as a victim, perhaps a potential victim of trafficking, is relevant to the assessment of personal responsibility and risk. That's the first way in which it's put as being obviously material. And the answer to that is that the assessment of national security risk is a matter for the Home Secretary on advice. It's an evaluative, predictive judgment with all of the features that I've already identified, and it is a matter for the Secretary of State, we submit, to deal with that as it considers appropriate, how best to assess national security, what factors are to be taken into account, what weight to give them, what avenues need to be chased down before reaching an assessment in which they can be confident. All of those matters are matters which were the subject of deep consideration in Begum and U3 and all those other cases. And I made the point earlier, you certainly can be a threat even if you know the traffic, so we're back into all of that. And so we respectfully endorse and agree with SIAC's judgment of paragraph 285, effectively concluding that in their view the security service is not merely, as they put it, well placed to make those sorts of judgments on voluntariness and degrees of commitment, but also that those issues fall within their institutional and constitutional competence. That's an echo of Begum and of U3, and indeed to factor in the implications of that sort of finding. So that's the first basis already dealt with, and of course all of those points were in fact considered in the national security assessments, as you've seen. The second way she puts it is that there is a public interest in a decision in depriving an individual on the basis of acts done in the course of trafficking which the state has failed to protect against. Well, that takes on back to, tries to put a common law spin, as it were, on that aspect of the Article 4 case that I dealt with earlier on. It's as well to bear in mind that that submission as put, and again it's 33 of the skeleton for the other side, is based on two findings, neither of which SIAC made, namely that she was trafficked and that the state did fail to protect her. And I've already made my points and I don't need to repeat them about the public interest and the attempt to build up that side of the public interest from Lord Kerr's speech in Hashim Ali. I've taken my stand, as I say, on 31 and 32 of SIAC's judgment, and I don't go back over those points. So we submit that there's no more in that way of trying to create as mandatory the need to view the Section 40 decision through the trafficking lens, or to consider the legal consequences of the label attached to trafficking. What everyone was concerned about in Section 40 was focused in on all features, including maybe some of the underlying facts I made clear before the short adjournment, but all features that might bear on that issue of being conducive to the public good. So that's what we say about the public law side of it, building on what I've said about the Article 4 aspects of that, of that decision, and whether it was mandatorily relevant under either basis to take those into account. I was going to move to procedural fairness, unless there were other issues on that topic. Procedural fairness is ground 4. We've dealt with this in our skeleton between paragraphs 44 and 58. And you'll be aware that the first point in relation to all of this is whether or not the statutory scheme provides for a procedure that is in effect exhaustive. The position has, for some years now, been an acknowledgement based on the judgment and reasoning of Mr. Justice Flo, as it was, in Al-Jeddah number 2. The position has for many years been that there is no right to make prior representations under this statutory scheme. His judgment, sitting in SIAC with Upper Tribunal Judge War and Sir Stuart Eldon, is at tab 26 in volume 1 of the authorities. And in fairness to him, given that there is disagreement in effect with his reasoning, let us take you to what that reasoning was. So tab 26 of volume 1 of the authorities.
And this is a conclusion that SIAC reached. The conclusion that SIAC reached was one that they reached with considerable hesitation. That
Yeah.
I think, or words to that effect.
In our case,
Yes.
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 Well, the starting point is the reasoning of Mr. Justice Flo and Al-Jeddah.
Yeah, yeah.
No doubt why they are respectfully cautious. Just to give you the points before we get to the paragraph I'm going to want to start with is one. Bits of it. The relevant passage in the judgment dealing with this point runs from paragraph 141 on page 630 through, in effect, to the end of 160. So it's about 4 or 5 pages. I'm going to trace back through that in a second, just to pick up little bits, as that were. But can I give you the short punchlines on the reasoning before we do that, so you know where I'm going, in case it feels like a daunting number of pages? There were 2 reasons why he concluded that effectively there were 2 core reasons why he concluded that there was no right to make prior representations under this statutory scheme. Reason 1 was that section 40, subsection 5, provides, as he put it, an exhaustive procedural framework. Take that wording from 156 of Al-Jeddah. Reason 2 by reference to Lord Sumption's judgment in Bank Mellat was that where, I take this from 159 of Mr Justice Flo's judgment, where there is a full right of appeal on the merits, such as in the present case, in our judgment, the absence of prior consultation does not render the decision procedurally unfair. And those were independent or cumulative reasons. Can we just see the reasoning as it goes through in a little more detail, and then it will save me having to go to Bank Mellat, which is part of the reason for doing it this way. You'll see the question which is posed at 141, 3 lines there to 141. And you'll see the relevant parts of section 40 sub 5 quoted in 143. You'll see the submission made by Mr Hickman, who was saying, no, we've got a right to prior representations. You'll see the argument being mounted and described in the following paragraphs, and you'll see the first citation from Bank Mellat, Lord Sumption, in 145. Note in particular the description of his conclusion at paragraph 32 and the 4th line of 145 of Mr Justice Flo's judgment. He concluded at paragraph 32 that unless the Act expressly or impliedly excluded, fairness required, and so on. That was on the facts of Bank Mellat. At 33, he then said, and you see what Lord Sumption says, not so interested in that paragraph from Lord Sumption, more interested in the paragraphs that are then quoted in paragraph 146 of Mr Justice Flo's judgment, especially the passages on page 632. Can I invite you to read that hours 35 through to the end of 37 of Lord Sumption's analysis in Bank Mellat? Can I particularly ask you to note the final sentence of the quote from Lord Reed in Wiseman and Bournemouth, which Lord Sumption describes as being consistent with the ordinary rules of construction statutes and remaining good law.
Yep.
Yep.
This judgment was before the amendments. Add section 5, subsection 5, capital A, and so on.
That is right. Can I check that rather than giving you an off-the-cuff answer? This one is July 2014, so someone might chase down when that amendment was made.
The Wiseman and Bournemouth statement is obviously just it's an independent statement,
Yeah.
not linked to section 40.
No. It's really for that test in the last 4 lines. It must be clear that the statutory procedure is insufficient to achieve justice, that to require additional steps would not frustrate the apparent purpose of the legislation. And in 37, he deals with the reasoning that was applicable in that case, in other words, in Bank Mellat. And you'll see in particular the restricted right of review. In section 63 of the Act that they were dealing with.
That was the Counter-Terrorism Act.
Yeah.
Yeah.
And Mr. Swift makes some deeply persuasive submissions in the paragraphs that follow, including the one at 155. I say deeply persuasive because that's the way the court perceived them. At 155, noting that in Bank Mellat and at Party Fired, there's no right of appeal against the relevant decision, only a right of recourse by way of judicial review or its equivalent. dispositive reasoning, having summarised those arguments and given those citations, is really between 156 and 161. Well, that should cast an eye down the road. So I hope you'll see from those paragraphs that it wasn't an unfair or inaccurate summary to just give you the two short bases of reasoning. One, it's exhaustive, really 156 and 157, and then 158 and following is all about the nature of the appeal right. And the passage from Wiseman and Borman that I drew attention to in 146 on page 632. Can I just invite you, I don't invite you to turn it up now because there's no need, but can I invite you to note next door to that little passage, that end bit of the Wiseman and Borman quotation, see also ex parte M, bundle 1, tab 13, page 165, sorry, paragraph 165, sub 3, where the court said the underlying statutory objectives must not be stultified by an overzealous superimposition of common law procedural requirements. It's on the same, actually it's on the same theme. So that's ex parte M, bundle 1, tab 13, paragraph 165, 3. So we make three short submissions on this point, therefore. First, this is not a case where Parliament has remained silent. Parliament has spoken. Section 40 sub 5 imposes procedural requirements on the deprivation process. Section 40 sub 5 and 5 capital A set out when the notice must be given before making the order and what must be included in the notice, that's 5A. It requires the Secretary of State to give notice in writing to the person against whom the order is proposed to be made. That is an important and a substantial requirement on the decision maker, which has real benefit to those who are subject to the deprivation of power. It enables the person to know why a decision was taken against them and triggers the right of challenge. It is, as Mr. Justice Flo correctly, as we submit, concluded an exhaustive procedural framework on the basis if they wanted to do more or to give more. It's very surprising that they don't say so, having gone to the trouble of setting out what those limitations are. That's the first submission. The second submission is it's not really surprising they dealt with it in that way, because although the context is not limited to national security, the context of Section 40 decision making very often will involve either national security or similar public interest considerations of the same ilk. And that fact renders it entirely likely that Parliament would have been concerned to set and to circumscribe the precise nature of the procedural duty on the decision maker. As a general matter, and there may be exceptions, I'm sure Mr. Squire can say that, but to some extent one can accept it, but as a general matter, the provision of opportunity to make prior representations will, in a considerable number of cases, it may be agreed that in the vast majority of cases, it will lead to a real risk, or some risk at least, of the person being afforded a prior opportunity to make representation in fact what truly required. Because you can serve to file, as you know, that was what was done in this case, you can serve the notice of the sub 5 to file, but if you have to give them the opportunity to make prior representation, that leads to the real risk that a person may seek in a variety of different potential ways to escape from the consequences of the deprivation. renouncing their citizenship or returning from abroad early or whatever it may be. And that is a general concern which explains and supports the idea that Parliament would have been concerned to provide for an exhaustive procedural scheme, because what one is looking for is Parliament's intention in specifying that particular process, brackets, and no other. The third submission is the one that I've already flagged when I was going through, I hope conveniently, the Supreme Court's judgment in Begum, Lord Reed's judgment in Begum, and indeed the Court of Appeal's judgment in U3. What is clear from that combination of authority is that neither of those two judgments, nor indeed a correct understanding of the true nature of the appeal which is conferred by this legislation for our purposes, neither of them requires any departure from Mr. Justice Flo's reasoning. You will remember Lord Reed identifying the distinction in the 1997 Act that creates the 2C, 2D, 2E and all that. The distinction which is specifically drawn on the face of that legislation between the appellate right, which we're dealing with, and the JR type right, only on principles of JR. And you'll remember all of that. But SIAC, we submit, is not the alter ego, one wants to view it in those terms, of the administrative court from a jurisdictional perspective. An individual against whom a deprivation order is made has a right of appeal to the Secretary, to the Special Immigration Appeals Commission. There's no need to apply for permission. And indeed, as is now clear, and as the judgment of SIAC acknowledges and prays in aid, SIAC does have, as they put it, a more powerful microscope. That was the phraseology that I think has filtered through into the case law, including the Court of Appeal in U3, a more powerful microscope than the administrative court. And that in part flows from the idea that they may be more ready to receive witnesses. It in part flows, and in large part, flows from the idea that they can in fact consider material which postdates the decision, and in certain circumstances make their own judgments and their own findings of fact. So in short, the factors that differentiate a SIAC appeal from a JR are those carefully analysed by the Court of Appeal in U3, it's our submission, paragraph 171 following in particular, tab 58 of volume 3. And indeed, as SIAC expressly acknowledged, and maybe that's what led in part of their reluctance, SIAC found the appellate process is not irrelevant here, judgment of SIAC here, paragraph 348. But going back to U3, all of the features that are there set out support the idea that this is an appellate jurisdiction. And to the extent that there are limitations on the ability to interfere with or second guess the decision making of the primary decision maker on whom that function is conferred by Parliament, they flow from the range of factors analysed by Lord Reed in Shamima Begum first time around, including in particular his analysis, which you'll recall I drew particular attention to, which is that there is no, as it were, inconsistency between acknowledging that a body is operating as an appellate body on the one hand, and on the other hand, recognising that as part of a proper principled approach as a matter of law, they give respect. So there's nothing inconsistent with it being a pure appeal body, but exercising their functions in that way. That was the wisdom that one derives, or a strand of the wisdom one derives from Lord Reed's analysis in Begum. And we also note, for good measure, that in U3, see paragraph 171 again, the court stated the appeal may well be the appellant's first and only opportunity to influence a decision maker. effect, that was being used as a support or a partial hook for the idea that the appellate function is an appellate function within the proper limitations that were identified and analysed in U3, and that the trial opportunity to make representations is not inherent in the scheme. And our respectful submission is, no doubt in part because they weren't assisted by the reasoning and analysis of the Court of Appeal in U3, but that the SIAC did not view the matter in that way, did not in particular consider this true nature of the SIAC jurisdiction in relation to these sorts of appeals in that way. And the final point perhaps to bear in mind in relation to that, I've made already, is that that does stand in a pretty stark contrast with the Bank Mellick case, in which, as we saw, it was critical to the decision, absolutely critical to the decision, and that it was concerned with a review under Section 63 of the Counter-Terrorism Act 2008, and by virtue of Section 63(3, in determining whether a decision should be set aside, the court must apply the principles applicable on application for judicial review. And so that was, as it were, a pure JR context that was being considered in Bank Mellick. They didn't have the advantage of the more powerful microscope. They weren't dealing with the same jurisdictional base at all. So we submit that for those reasons, there is no proper basis for the interposition into this statutory scheme. Of course, it always remains open to the court to consider whether it is necessary to do that, applying the Wiseman and Foreman test, which the assumption expressly approved. But there's no basis for doing that here, where Parliament has gone to the trouble of setting out the scheme that it has, and where the clear implication is that they've done so exhaustively, because if they're going to do the prior rep thing, it's pretty surprising that they don't do it, having said what they've said about the provision of the notice. And we say appeal and the nature of the jurisdiction being exercised by SIAC is very, very important for obvious reasons. So but on that basis that we respectfully disagree with the conclusion that SIAC reached on that issue.
Now, Sir James, Mr. Squires was described by SIAC as having launched an impressive full frontal attack on the orthodox approach in Al Jeddah, and the judgment records a number of points. And Mr. Squires has, as he's entitled to do, kept his powder quite dry on this point,
Yeah.
indeed completely dry so far, orally. Are there any points from the judgment relied upon by SIAC that you haven't addressed that you need to? I'm looking, for example, at paragraph 325, page 157. There's reference apparently to a practice on the part of the Secretary of State on section 43 cases.
Yes, well, my lord, my lady, I'm not sure that point takes one any further.
I understand, we're just giving you the chance
Well,
to...
I'm grateful for that. I mean, our submission in relation to that is, I think, that those are different contexts. We're not dealing with the sort of thing where the run-of-the-mill case is a national security concern, such as this context. But in any event, so far as the point is made about a practice, that doesn't assist in any event, because the first of the questions is a question of statutory interpretation.
Yep.
Many is the time I've longed for the idea that the Secretary of State's practice could affect the meaning of legislation, but I've never normally been allowed to run that argument. So
You're not going to be allowed to now, are you?
no, well, that's the short answer to that point.
Right.
I think in fairness to us, the debate below and here really does centre around those two critical features of
Right.
Mr. Justice Flo's judgment.
Thank you very much.
Is it exhaustive, and is it equivalent to JR? Effectively, two questions.
Thank you very much.
Thank you for the opportunity on those. I was going to move to immaterial error or simplex, which is procedural unfairness. And on this basis, we assume that there is a prior right to make representations and it wasn't afforded. And our submission
Sorry,
here.
Sir
Yes.
James, maybe that you're coming to this, but it seemed to me that paragraph 341 of SIAC's judgment was quite important. having decided the point of principle in this, they say the giving of the postulated opportunity to make representation to national security. The Commission's experience is this will usually be so if the individual is outside this country, not least because prior notification runs an unacceptable risk of precipitating his or her early return.
Yes.
You added a few minutes ago, or renunciation of the alternative citizenship.
Yeah.
Is that, seems to me, quite an important
And it is quite an
basis for
important
their
point.
decision on ground 4. Are you,
Yes, there's a bit of subtlety with this bit.
Yes. All right.
You'll have noticed that I
Yeah.
that I ran this effectively that point was as a general point going to assist with the interpretation of the legislation
Mhm.
and with a discernment of Parliament's intention, because the general run of cases going through in relation to this power would be national security cases running that sort of concern.
Yes.
What this paragraph is dealing with, 341 and following, is whether or not, assuming I'm wrong about that,
Yeah.
there is then nevertheless the impossibility, impracticality or pointlessness exception, as it were. So that assumes that
Seems there's jurisdiction, but nevertheless says that
it says that
there's
there
common
are
law,
exceptions
but
if you
here-
can make that good
yeah.
in the application of them. So I'm arguing for, as it were, a position prior to that, but relying on the point to which my Lord drew attention, which we respectfully submit is an important point, but relying upon it as a general point in relation to those powers to assist with the discernment of parliamentary intention. Is it an exhaustive scheme or isn't it? How would they have set it up? What was the intention there? As opposed to, as it were, trying to cram myself in this case, to the impossibility or impracticability characteristics that may or may not feature in this case, because, as Mr. Squires rightly points out, she is in a camp in Syria and there's no possibility of her moving anywhere else for the time being. So those points about impossibility or impracticability that I rely upon are relied upon as general points for the purpose of the statutory interpretation exercise, and are not undermined by the ability to identify exceptional cases in which these exceptions might apply. If that makes sense.
Yes.
So that's how we put it. This is at one stage further on, but we do respectfully agree with my lord that bit in the middle is very important, but it's important in that way as assisting you with what Parliament might have intended when enacting the scheme, which is obviously Mr. Justice Flo's first reason, is it's an exhaustive scheme on its true interpretation. And obviously the pointlessness one is a bit, that takes one into simplex and the material, no material impact and so on. So that I was going to term the simplex or immaterial error point. And our submission here is that SIAC was right to find that error was immaterial. There was no error of principle, and there was a proper evaluation of the key question to which it gives rise. And we make these submissions about that part of SIAC's analysis. You find it, if you still have that judgment open in the next little bit, it's really from 344 and following is really where you find it in the SIAC judgment, this aspect. And our submission is firstly that they apply the correct test. High hurdle, inevitably the same decision, hypothetical, reasonable and open-minded Secretary of State is the approach. 345 in the judgment, and indeed it appears to be the position that at least a large part, if not all of that paragraph, is accepted to be correct by my learned friend Mr. Squires. Mr. Squires referred to cases on the statutory provisions in similar territory in section 31 of the Senior Courts Act, 1981, which the Admin Court very regularly comes across, as you know, for the purpose of considering whether or not relief should be granted. Similar sort of jurisdiction. The question there, doesn't mean it's different for this purpose, but the question there is whether it is highly likely that the result would be the same. But although the test is formulated in that way, the basic underpinning in principle is the same, and the approach is therefore instructive. We submit, but those cases we also submit do not actually help him. We have in volume 2, tab 39, I'd like you to take that up, and whilst you're getting that, we might hand up one other grounds of appeal that I might refer to. I'm handing up 2 documents, if I may. One of the application.
Has Mr. Squires seen these?
I think he has now. Apologies for. We will have done any minute.
If you need longer than 5 minutes in a moment, Mr. Squires, you can have
I
them.
need one. I will
Knows
need
all
one.
the authorities by heart. Eh?
Only for a short passage. If you have the description in
Thank you very much.
2 tab 39, in Goring, it was in the bundle, and it's paragraph 55.
Right, let's start with Goring, shall we?
Yep. This is the Court of Appeal, Clarence Etherton, Master of the Rolls, and all Justices Lindblom and Coombe. Cone. There's no one. 55. It's really the last sentence in that paragraph. The court must necessarily undertake its own objective assessment of the decision-making process and what its result would have been if the decision-maker had not erred in law. So that is the function of the court. It's being asked to make a judgment itself. It can place itself in the shoes of the decision-maker in the way that the SIAC correctly identifies in 345, but it's ultimately for it to make that assessment on the basis of its own objective assessment and so on of the various features that are then identified in that final sentence. And it's that which is drawn on in the Glatter case, Mr. Justice Kerr, which we'd like to put behind tab 74, and the paragraph for that purpose is just a short extract at paragraph 99.
Well, that doesn't take us much further, does it?
No, it cites from Goring.
So,
Actually, that's not well much further, but anyway, if the summary is helpful, it's there. So our first submission is SIAC applies the right test, right height of hurdle, right approach, objective judgment for it. Second submission is again one of principle. I do not accept that it is not open to the decision maker to surmount that test, or for the court to conclude that that test is not surmounted more accurately than the objective thing just identified. I don't accept that the test involves in effect establishing that no decision maker could rationally have done anything other than maintained the decision. The test is for the court, putting itself in the shoes as indicated, to make its own objective assessment, as Sir Terence and the rest of the Court of Appeal put it in Goring. And the core point at this stage is not merely do I not accept that that's the right way of looking at it, he's trying to back the law into a position of impossibility, into a position where it's impossible in effect to meet the standard. But nor do I accept his point about flipping the leeway given to the Secretary of State around the other way. The core point is that when the court asks itself that objective assessing question about what the result would have been and would it have never been the same, it can and should, as SIAC did, acknowledge the expert and experienced and very difficult to challenge views on national security of the decision maker, because those are views that would be recorded respect precisely on the assumption of the reasonable, open-minded Secretary of State in this context. And the focus should be on that, particularly bearing in mind the particular weight that is given to national security considerations in relation to Section 40. And this is the fifth submission, it's clear, or we say SIAC was obviously entitled to reach the conclusion of fact and evaluation that it did when applying that test, having regard to the totality of the evidence and information that it had before it. It was extremely well placed to make that judgment, and its judgment on that factual issue, hypothetical though it may be, is informed by all the actual evidence it had. It was extremely well placed to make that judgment, and therefore particular respect accorded by this court to that exercise. But you will bear in mind one particular feature of that, which is that SIAC did have the benefit of the updated national security assessments. You go back to that ability to take into account material that is generated and reacted to after the event, as long as it's relevant to the events of back. But they've done the exercise, so my learned friend says, well, there's nothing to support any of this. The answer is they have direct evidence supporting this, because some of those later ONS analyses, as you will recall, were directly reacting to the evidence that have been produced, including the expert evidence that have been produced on Ms. Begum's behalf. But we respectfully submit that when you get into the core of the SIAC analysis, they were perfectly entitled to reach the conclusions that they did, which were in essence that any attempt by Ms. Begum to challenge the national security case at the pre-decision stage would have been fruitless. 345, 346, only a short period would have been allowed to provide representations. SIAC correctly found, as a key point on that at 347, that it was not impossible to provide valuable instructions on the basis that they hadn't even been provided at the time of the hearing. I know all the points about the impracticality of trying to get instructions from her, but everyone is now proceeding at least on the basis that there was no possibility of her being invited to, as it were, put her side of the case or assist anyone in relation to the facts. There was some suggestion below that there should have been service and an opportunity in the Owl Hall camp or the Owl Lodge camp, but that is no longer pursued. And I do respectfully submit that it's unrealistic in the extreme. This is the second document we've had unrealistic in the extreme for my learned friend Mr. Squires now to make the submission that you can proceed on the basis that effectively, when asked the question what would have been the trial representations, it's the entire case to SIAC, stripped down potentially or at least a little bit to the idea that it's all the essential points. And that's part of the reason, forensic though it may be, and I'll make it very short here because it probably is more forensic than anything, but one looks at the grounds of appeal and you see the dates on which they were originally submitted. The first date, which has no underlining and no crossing out, was the bit that was submitted on the 19th of March, that is a month after the decision. if you're looking for a flavour of what might have been said by perhaps lawyers alone, as it were. And then they're amended in May and amended in July, but it's really the original version of this that will tell you what might have been said and what was said. But none of that, we respectfully submit, assists, and it is certainly not to be assumed that all of the bells and whistles that were then produced in the SIAC proceedings would in substance have been produced as part of these prior representations. There would obviously have been a reasonable desire to get on with things, even as prior opportunities have been afforded, relatively short window, possibly 14 days, I don't know, but it would have been nothing like the entirety of the case. I say I don't really care whether it is the entire case, because the entire case was reacted to in the National Security Assessments anyway, as part of ONS2. So we submit, our short submission is that none of what SIAC did impermissibly trespasses on the functions of the Secretary of State or the Security Service. There was no accession or exceeding the institutional competence of SIAC, and all of the findings of fact that it made, and they were for it doing the objective assessment, were ones that they were entitled to make.
Should we put this late document behind page 82 in Supplementary Bundle 1? It's just before the skeleton arguments before SIAC.
My lady, yes, that would be very helpful, thank you.
It's a very logical place to put it. So I'll do 82A through to D.
Thank you.
Yes.
And maybe if you were not assisted by Ron Blatter, that would go in the bin.
Yes, Ron Glatter's not going anywhere.
Hope at the conclusion of the court. That's all I wanted to say about simplex and all of that. De facto statelessness. Ready for me to move on to that. De facto statelessness. Ground 3. I'll scale as an argument for this court, paragraphs 34 to 43. The starting point is at least to recognise that section 40 sub 4 applies, as I think we will accept and agree, to de jure statelessness only. That's statutory preclusion. I don't think anyone is showing much inclination to get stuck into the question that we considered a bit below, which is whether or not de facto statelessness is really an interesting thing, or the right thing, or a thoroughly distracting thing as a concept, because there is considerable international legal controversy about what that concept actually means, if anything. And but I don't think any of us is saying that there in much terms on that. You just need to acknowledge that international legal issue is out there. And the reason you don't need to worry too much about that, I think, for the purpose of this appeal, is because there appears now to be little or no dispute that SIAC, in its judgment, properly framed the relevant question. So it did not commit any error of principle in its approach to the question. Was the practical impact of depriving Ms. Begum of her British citizenship properly considered by the Secretary of State? Did he effectively appreciate that there was nowhere for her to go if she was deprived? That you can take from a summary of Mr. Squire's submissions below at paragraph 297 in SIAC's judgment, and their accepting of that and setting of the test at paragraph 302. We note before coming to the main event that the starting point is not that SIAC accepted that this was a mandatory relevant consideration. It went no further, 304 of the judgment, than noting how the Supreme Court considered issues of de jure versus de facto statelessness in FAM. But as we all agree, SIAC accepted at 302 that this was not in fact really an argument about de facto statelessness in the way that it's sometimes been understood in the authorities. It's about the impact, simply about the impact of the consequence of deprivation on Miss Begum. So that is not within the mandatory relevant consideration category, and SIAC did not so decide at 304. There is no dispute that the Secretary of State was in fact told that there was no real prospect that Miss Begum would or could go to Bangladesh, which was the only other candidate. It is clear that the Secretary of State was advised about that fact. See for that purpose the mistreatment risk statement which accompanied the ministerial submission, supplementary bundle, page 745, at paragraph 6. We do not consider that a repatriation to Bangladesh is a foreseeable outcome of deprivation, and as such the Home Secretary may consider there's no real risk of return. Brackets there. And it appears from their skeleton of paragraph 45 that Miss Begum herself also accepts that, in her words, it was clear to the SSHD that Bangladesh would not admit her or provide her any protection. Moreover, as SIAC itself recognised, the Secretary of State would know, and did know, that she was stuck in the SDF camp, did not have a passport, and was unable to travel in any event. See paragraph 303 of SIAC's judgment. And I go through those matters because they make clear that the dispute is really about labelling under this ground. No doubt that's why SIAC at 302 referred to the idea of labelling. But the scope of Miss Begum's argument now appears to be that it was not enough for the Secretary of State to have been told the substance of the issue. And we submit that is sufficient. It isn't interesting or legally relevant that those facts, those base facts about having nowhere else to go, were brought to the Secretary of State's attention for a different immediate legal purpose, as it were, which is to ensure compliance with the A2, A3 policy. For a material consideration challenge, which is what this is, what matters in law is whether the issue was in fact considered. It plainly was. It doesn't make any difference that the label or the headline under which the point of fact appears was a different label or a different legal context. That would be a picture of form over substance, we submit. So if and to the extent that it said this was, i.e. her inability to go anywhere else, a mandatory relevant consideration, the point is that it was in fact considered. And of course precisely how and what weight to give to that point is a matter for the Secretary of State. There's no rationality challenge to this, it's just simply was the mandatory relevant consideration as asserted taken into account. And we respectfully submit that the reference or the reliance on anxious scrutiny, which was the second limb of my learned friend's challenge here, by reference to Lord Justice Khan was as he then was in YH, tab 22, paragraph 24, we respectfully submit that adds nothing. It simply refers to every factor being taken into account and considered. It doesn't tell one anything about the need, as it were, or a perceived legal need to put a particular label around the fact which is to be considered. And here, all the relevant stuff was considered, including the chair nowhere to go. So that's all we say about de facto statelessness as an inaccurate description of impact. That leaves me, I think, only with PSED as the final topic. Begum relies on section 1491A. You need to have due regard to the need to eliminate discrimination, victimisation and other conduct prohibited by the EA. Equality Act 1411 1491C, fostering, need to have due regard to fostering good relations between persons who share relevant protected characteristics and persons who do not share it. You have that section, if you want it, in the Authorities Bundle 1, Authorities Bundle 1, tab 3. But as this turns up, it's a very well-known provision. There's no suggestion that the decision to deprive her was discriminatory. The challenge here rather appears to be an entirely general one. But we do note this isn't a JR of a policy or a generalised practice, none is sought to be identified. It simply said that there are some potential worries or impacts that flow from that deprivation decision, good, bad, well-founded or not. And we do note in that respect that as the Supreme Court, Lady Rose giving the judgment for the court in Maroof, we note what she said at paragraph 62, which is that the PSED is primarily directed at policy decisions, not at the application of the policy to individual cases. We submit first that Maroof is of real interest in determining whether, in a context such as this, with a specific decision about an individual, where no allegation is made that the decision itself was in some way discriminatory, but the only thing that, as it were, brings it to this jurisdiction at all is asserted impacts on other community groups within the United Kingdom. We do respectfully submit that Maroof is informative about whether or not that sort of challenge, i.e. Ms. Begum's appeal against the deprivation decision in her case, truly was intended to engage section 149 and the mandatory due regard principle. I put it that way deliberately because Lady Rose at the end of her judgment was concerned to make clear that that was the issue with section 149. Do you have to give due regard in all circumstances falling within it? That's not to exclude the possibility that sometimes some other types of impact might rationally need to be considered or might rationally be capable of being considered. So that's the game we're on. And the analysis of the Supreme Court in Maroof, Authorities Bundle 3, tab 57, was to the effect that you need to exercise very considerable care before concluding that that section applies extraterritorially. Now that always engages the question, well, what on earth does extraterritoriality mean? One fully acknowledges that. But the basic reasoning of the court flowed from the usual presumption that legislation is assumed not to be territorial, not to be extraterritorial. So maybe as well to have it, tab 57, paragraph 40. You see the context perhaps in the head note at 1793 line, tab 57, bundle 3. There was a debate about the correct approach to legislation, but you see what is said in paragraph 40, starting at the bottom of page 1805, using the bundle numbering. Legislation not generally intended to have extraterritorial effect. High threshold, see paragraph 41. And then in 53, the fact that the decision challenge was taken in the UK does not mean that the PSED requires due regard to be had to all the effects of that decision on anyone wherever they are in the world. So again, it's a bit like that idea from Bankovich. You don't say, here's the jurisdictional link because you've made a decision in the United Kingdom and the impact is outside. And ultimately their conclusion at paragraph 54 was that there was nothing in the wording of 149 from which it could be inferred that the presumption against extraterritoriality had been overridden. And of course, in that case, no doubt it was perfectly possible, given that the allegation was that the only people who were excluded from the relevant immigration scheme that was an issue in that case were Palestinians. It was entirely possible that there might have been concerns in the United Kingdom amongst the Palestinian community or whatever it may be, but the analysis of the Supreme Court was clear. Start with the presumption against extraterritoriality. It's a big thing to overcome that. It doesn't do it just to say the decision is made here. So what then about here? What about the position here? We submit that that reasoning and that analysis is of real interest here, because the effect and the true effect in relation to this decision is an effect on Miss Begum, because she is deprived.
When you say of real interest, what do you mean?
I mean the target of the SIAC appeal is the decision made in respect of her. It was her deprivation that was an issue. Now, to some extent, I see, and one can see the argument that says, well, nevertheless, what's actually being raised is an impact or a potential impact on communities within the United Kingdom. And I fully acknowledge that that's the way in which the attempt is made to create the jurisdictional link. My query on the back of my submission on the back of the reasoning in Maroof is that won't do it, because those impacts, one assumes them to be correct, as it were, but those impacts are adventitious and are, on any view, subordinate to the main impact and the key impact, which is on Ms. Begum.
But to be clear, are you saying as a result of the reasoning in Maroof, section 149 is not engaged?
Yes, that's our submission. Lady, I'm sorry, I should have made that
No,
very clear at the beginning.
I'm thinking
Yeah,
anyone can
we're
understand
disagreeing.
that, so-
We're disagreeing, I think, in this respect with SIAC. This is one of our respondents' notice points.
Understood.
So the effect here that is relevant is on her. She is the personal matter outside the UK. And the fact that there are some UK impacts on the decision that does not produce a territorial bite that it doesn't otherwise possess, when the focus of the decision is on the personal matter, is outside the UK. Because otherwise one can always say, reasoning in Maroof, well, these are decisions that relate to people outside, and they have lots of impacts, no doubt, elsewhere as well. But as long only as I can identify some ground for worrying about whether they might have impacts in this jurisdiction, that's enough to, in effect, create 149 as an obligation, which requires those impacts to be taken into account in taking the decision about the person who's outside.
I've gone blank. Did SIAC deal with Maroof?
No, it was decided afterwards.
I was going to say I was checking
Yes,
the date.
I'm sorry, I should have made that
No,
clear as well.
no.
They do deal with the
March
point at
2023.
394.
Yes.
I should have started the other way around. They were dealing with, so Turani is Maroof.
Right. Yes. So
Yes.
paragraph.
Right. But that's Turani CA.
Yeah.
We now have to pay particular attention to Turani CA on account of the thoroughly running elevation of
Yes.
Justice Simba. But that was Court of Appeal, and Turani and Court of Appeal became Maroof in the Supreme Court.
But the Supreme Court agreed with the Court of Appeal, didn't it? So
Yes,
they stand
on
together.
this. So That's what we say, and as I say, that, of course, one can say, well, there's a difference between the two cases, because in Tirani or Maroof, it was all outside. The whole thing was outside. Everything was outside, and one is there. But we submit that if you're trying to grapple with the principal question, which is, well, what degree of impact matters? What degree of impact in the UK is sufficient to overcome the presumption against extraterritoriality of the kind that Maroof decided? We submit that the best and proper starting point is to look at the nature of the decision and who that decision actually affected and where that effect took place. So that's how we put it, anyway. That's the first submission. The second submission is 192.
Yes.
Yeah. It might be as well to have that open. It's in Authorities Bundle 1, Tab 2. Put the rule there if you would.
Or paragraph 384 of the judgment.
Or paragraph.
384 of SIAC's judgment.
Probably even better. Yes, I'm sorry, that's much more convenient. Yeah. I was giving you a Duff reference anyway, so this is where we're at. So 384 of the judgment, thank you. And you know what SIAC's reasoning was here, 387 in particular, and following. So I'm not going to trawl back through all of that all over again. They correctly concluded that the natural and ordinary meaning of doing and anything in 192 could only sensibly be understood as a reference to the exercise of a function under separate legislation rather than any obligation under the 2010 Act. So the doing must be the exercise of the Section 40 power. And that is because 192 does not look at duties and obligations imposed under the 2010 Act, but to functions elsewhere. And that reflects the ordinary and natural meaning of the reasons they set out. So my learned friend's case now appears to be, well, proportionate to what, and why isn't it proportionate to override the duties that would otherwise be applicable under the scheme of the Equalities Act? That suffers from a number of difficulties we submit, one of which is that you have to try and read in something that looks and smells a bit like the additional words that my Lady Justice Whipple was putting to him, and that is not a bad indicator that you're not quite on the right lines if that's what you're having to do. I'm allowed to make that point in that way. But the other thing is that one just needs to read sensibly the language which is before us, bearing in mind that Lord Hodge's injunction to do precisely that when you're considering an exercise of statutory interpretation in Project for British Citizens. And if you do it that way, it is entirely evident that the concept of proportionate here is linked back to the purpose. Anything it's proportionate to do for that purpose. And the purpose that is referred to is for the purpose of safeguarding national security. One sees that from the bounce back in the wording. And so the question then is, well, what does proportionality add? And the answer is, if I was looking at it in that broad purposive way, the answer to that is that it as it were imposes a standard on the national security judgment. It doesn't necessarily or at all import the need to compare and contrast with the idea that you might be breaching the provisions in the Equalities Act. And so it would engage with ideas such as you can't just turn up and say it's made for the purpose of securing national security, that's it. That was my legitimate subjective purpose and aim, and that's the end of it. Nor indeed can you say, well, my view is it's national security, even if there are other less intrusive ways in which the same national security threat might have been dealt with. So we submit that proportionality for this purpose is sufficient unto itself and is to be viewed within the prism of the national security judgment to which it is linked, and does not bring in, as it were, a comparison that says, why do you need to breach duties that would otherwise be owed? To which my learned friend's best answer then appears to be, well, how does that work if it's direct discrimination, and wouldn't that all be ghastly? To which the answer is, the whole purpose of 192 is to create a national security exception to the need to comply with those duties. And in those circumstances, this is operating as the gate to that exception. And you can define the gate in any way you consider appropriate. It's just saying national security hands off and hold like it. It's direct or indirect, you're just not going to engage. So, referring, as it were, to a submission that we once upon a time rejected on the basis I was behaving like the fat boy from Pickwick Papers and trying to make the court's flesh creep. But that the direct discrimination argument is a bit like that. And I respectfully submit that it doesn't work for that reason, because this is designed to create an exception. And all this is doing is setting the gate. It's
Are there any
defining
other similar exceptions in the Equality Act?
not as far as I'm aware, we can check. This is certainly the
Thank you.
key one for present purposes.
Thank you very
So
much.
you say SIAC got it right, I mean, you expanded a bit beyond 387.
Yes, I got it right, and the reason I'm addressing it in this way is because the argument that is now being presented to you is to some extent different, it's a little bit different, a lot. And it's, I'm not going to start taking points about changes of arguments, but I do submit that the way of putting it now doesn't really take one very much further. And again, if one views it in the way that I've been describing 192 as an exercise of interpretation, and you then go back at that point to the explanatory notes to which he took you, they, if anything, reinforce the arguments I've just been making about national security being sufficient unto itself, because they make absolutely clear in the explanatory notes that it is tied back to that. But the objective of the proportionality introduction to this gate defining provision is, as I say, to create, as it were, something less than a mere statement of assertion by a Secretary of State that that was the purpose.
What does the word proportionate bring into the discussion? I mean, the 192 exception could have said it doesn't apply to anything done for the purpose of safeguarding national security.
It could have said that. And
What qualification on that is proportionate?
I think it would require and allow for an analysis of the things like less intrusive measures to deal with the national security threat. I mean, of course, it could have just stopped where you described, but if it did stop where you described, then it would be open to the Secretary of State simply to turn up and say, I can escape from all of these duties under the Act if I assert that was merely my purpose. And as long as you, the court, are satisfied that was genuinely my purpose, you don't look at anything in relation to the national security threat at all. And no doubt Parliament was concerned that it shouldn't just be that wide open push through gate, and they were trying to bring in some form of control. It's a bit precisely what considerations might fall within the concept of allow you to control it in that way would have to be the subject of argument, but at the least it's not difficult to envisage some mechanisms of control. As we know, proportionality has built within its guts the examination of less intrusive measures to deal with the particular thing, the particular concern that was raised.
As regards the individual, I mean, does this say that the making of a deprivation order is for the purposes of national security is outside the scope of the PSED, provided that it is a proportionate way of dealing with the individual case? Yeah.
In our context, yes, because the Section 40 will always be that's the thing that you do, as it were. It will always be the focus of the analysis. But one can see the sense, as I say, one can see the way in which the policymakers or draftsmen's minds are going to work. It might be a slightly odd concept to be using, but they're, as it were, saying here we're creating a kind of shutdown to these quite important duties. We're creating an exception. National security doesn't need to be troubled and can't be troubled with these things at this stage because there'll often be problems and blah, blah, blah. And so what should the nature of that test be? Should it just be the Secretary of State asserting a purpose? As long as it's genuine, that's enough. No, we want something a bit more. Proportionality is the bit more. And that's enough for my purpose. What my learned friend needs to do is to go a whole further. And say, no, proportionality can only be understood as importing, which is why we get back to the implied words that are necessary to make this work. It can only be understood as importing the idea of proportionate in the context of, or in the sense that you are, as it were, you are otherwise breaching the act. Well, that's more like a trial of the discrimination issue than it does a gateway. So that's how we respectfully submit that that works. And so we do submit that SIAC were right for the reasons I gave, and to the extent the argument is a bit different, we're right. So that's what we say about that. The third submission is, and I'm done, is due regard in any event. And this is one of the areas in which there may need to be further submissions enclosed. The open material we have summarised and set out in our skeleton below, paragraph 205 D to G, supplemental bundle, page 263. And that refers to the contest June 2018 strategy, which we've given you reference to, and that was then taken into account in the ministerial submission at paragraph 3.1 at page 743 of the supplemental bundle, and the detail of how the assessment which was provided to the Minister was reached is set out in Mr. Larkin's second statement at paragraphs 17 to 21, supplemental bundle, page 855. And we submit in relation to this aspect that SIAC was right to recognise at 396 the arguments around 1491A don't really get off the ground at all. Islamic fundamentalist terrorism is and remains a potent threat, and it's hardly surprising that the Section 40 power has been used in that context against people who are largely, if not exclusively, of the Muslim faith. It pretty much could not be used against extreme right-wing terrorism because the exponents are highly unlikely to be dual nationals, the point that my Lord Justice Bean made. And in relation to Irish extremism, Irish citizens do not require leave to enter or remain in the United Kingdom under the Immigration Act, Section 3ZA. And we submit that that feature, those factual features, that context, and in particular the fact that the deprivation power can only be used against dual nationals, is key and is an inescapable feature of any exercise of the power under Section 40, to which regard must be had, as it were. And it's an inescapable fact that that sort of terrorism has been the prime threat to the United Kingdom and its citizens over the last 20 years. That point was evidence before SIAC. See, for that purpose, Mr. Larkin's first statement, paragraphs 13 to 21,
joinder.
It's a different concept.
If you lay on your back, a head hanging over the edge of the bed has a corrective.
Oh, really?
5 minutes.
Right, you don't have to do it overnight.
Yeah, that's what we're doing. And we're going to argue about it. And it may work.
Yeah.
That one about before.
My lord, Sir James began his submission by saying that the focus of section 40 is squarely on whether a person represents a danger to national security. In other words, it's all about risk. We say that is incorrect. The focus is on whether a person's deprivation would be conducive to the public good. Of course, national security is an important facet of this, but there are other important public interest factors, and compliance with ECHR obligations towards victims of trafficking and in relation to trafficking generally is one of these. Sir James also drew attention to the Hesham Ali decision and the finding of SIAC in relation to that at paragraph 32. We don't take any issue with what SIAC said about Hesham Ali. Weight is a matter for the Secretary of State. The point we were seeking to rely on is that the public interest is a multifaceted one. And it is accepted, as we understand, that in taking a decision under Section 40, as I said, compliance with the ECHR is always relevant and may give rise, as it does here, to the ground of appeal on which the Commission...
Sorry, compliance with Article 4, you mean?
Yes. Or it could, in another case, it could be on a different ground, but ECHR is always relevant. The ECHR obligations are always relevant where applicable to a decision to deprive. In this case, it said against us that there are these two completely distinct regimes, and that the trafficking has got nothing to do with the decision to deprive. But the decision, the trafficking of Ms. Begum from the United Kingdom to Syria, whether you look at it under Article 4 or under common law, was inextricably linked with the very basis of the decision to deprive, i.e. there is a direct nexus. The facts are very stark in this case and are accepted. This was a 15-year-old schoolgirl, born and bred in the UK, who was intelligent, doing well at school, who was groomed, recruited, in a situation where the police and the school were aware of risks but failed to act, and whose travel was facilitated, including with an agent under the employ of the Canadian authorities, who was persuaded to go to Syria for the purpose of sexual exploitation and married off as a child, something which is recognised under domestic and international law as forced marriage. And she remained in ISIL control until January 2019. The chronology of the events in this case is agreed between the parties and is set out in tab 6. And these facts form the basis on which this case needs to be looked at.
But
And
the
as I say-
basis of SIAC's approach, I've now lost the paragraph, we've gone to it many times, is an arguable case.
Well, an arguable case of state failures, but the actual facts
Right.
in this case are set out in SIAC's judgment and are not disputed.
But there's no is there an outright finding of trafficking?
Well, there's a finding of credible suspicion
Yes.
in this case, which
Yes.
is all that's needed.
Well, yes, but I mean, I'm not saying in any way that I, for my part, necessarily accept what Sir James has said about this, but I think it's important we're accurate. So,
But it's
credible risk of suspicion that she was a victim of trafficking.
the Commission's finding was a credible
Yes.
suspicion that she was a victim of trafficking, but the underlying, my point is the underlying facts of this case can't be ignored. The chronology is agreed in this case, and it forms the underpinning, if you like, of the decision. And the effects of this decision, this Section 40 decision, let us not be in any doubt, were absolutely devastating for her. They prevent her from being able to avail herself of the protection of the state of which she was a citizen, or to receive any assistance with recovery from trafficking from the UK. It's said that she's stuck in the SDF camp and there's now nothing that can be done to get her back, but that is not correct. If one looks at the decision of the Strasbourg court in HF, there is clear evidence that women and children are being permitted to leave the camps Al Hol and Al Roj, where states agree to take them. France was organising return on a case-by-case basis from March 2019, and that's paragraph 26 of HF at tab 70. The impediment here is essentially the deprivation decision.
Sorry, tab 70, paragraph.
Tab 70 of the authorities bundle.
Paragraph
26.
Paragraph
26.
26. The two regimes, the trafficking regime and the deprivation regime, are not simply ships passing in the night. Both have a wider public interest at their heart, just as the decision to deprive is not just about risk and national security, so the trafficking regime is not just victim focused. Sir James said it was all about protecting and assisting victims. It's also about the prevention of trafficking, bringing perpetrators to account, as well as obviously ensuring that victims are protected and assisted with recovery. And the clear link between trafficking and terrorism is recognised, and Article 4 obligations do not just simply be removed in a circumstance of terrorism or armed conflict. The UN Security Council has passed a number of resolutions specifically recognising that women and children allegedly associated with terrorist groups are often victims of trafficking. That was in our skeleton below, and the reference for your note is the supplementary bundle tab 4 and paragraph 80 of our skeleton below. Sir James says everything has been considered already by the Secretary of State in a series of assessments and relies on the updated security assessment, but there is no evidence that the Secretary of State turned his mind to his legal obligations when taking the decision. And given the evidence of trafficking and given the finding that the credible suspicion threshold was crossed, the questions arise, what should the Secretary of State have asked himself when taking the decision to deprive? And we say the very first question they should have asked was Ms. Begum an actual victim of trafficking for the purpose of sexual exploitation? There was a wealth of evidence known about her case by the date of the decision, and there was an enormous national media attention surrounding the girl's departure in 2015. Do they need to carry out a full-blown assessment of whether in fact she was an actual victim of trafficking in order to take the decision to deprive? We say not, but they need to consider that. Secondly, what are the legal obligations that they owe?
Sorry, so Paul, you said, so what's the complaint? They should have asked themselves, do we need to carry out a full-blown assessment? And they ought to have answered that question, no.
Well, no, they should have considered. They should have considered it. They didn't need, in order to take a decision to deprive, they didn't need to fully consider. The credible suspicion was the trigger, and then it is for the Secretary of State to decide how they're going to fulfil their legal obligations caused by the trigger of credible suspicion, the legal obligations to investigate and to assist with recovery.
I'm really sorry to press you. I just want to be clear, because your first question that I've noted down was, should have asked himself, was she an actual VOT? Now you're saying the question should have been, is there a credible risk, credible suspicion that she was a VOT? Just take your time, because this may be important.
By the time the decision was taken, there was a credible risk. There was a credible suspicion that she was a victim of trafficking. That's established by the judgment below. The question is, what were the consequences of that? What questions arose? What were the legal obligations which resulted from that? And did the Secretary of State turn their mind to those legal obligations? And we say no. How, for example,
I just want to be really clear about, I was interested in the proposition of what the Secretary of State should have asked himself. I liked that way of approaching it. And like my lady, what is the question? Is it, should he have asked himself whether there was, on the basis of materials before him, credible suspicion that she'd been a victim of trafficking for the purpose of sexual exploitation? Was that the question?
Well, yes, and that of course has been found in our favour.
Okay.
Yes.
I know that.
Yes.
I know that. But that was the question.
Yes, that was a question. Yes, absolutely.
Should then, you say, would have been bound, should then have concluded answer yes, and should then have gone on to say, in those circumstances, what are my legal obligations?
Exactly, that's
right?
it, my lady, exactly. And the two legal obligations we rely on in this case are the duty to investigate and the operational duty. So they needed to consider how, in taking the decision to deprive, how would that affect the ability to investigate? How would that impact? She would not be able to participate in an investigation to help discover who was responsible for her grooming, her recruitment, her facilitation. And in terms of the operational duty, how would the decision impact on her ability to access assistance with recovery from her trafficking? And as part of that, we also say they needed to ask themselves the question, well, given what we know about state failures, were there state failures, and how did they feed in to our legal obligations in terms of recovery and reparation?
So you're saying that the Secretary of State should have reached a conclusion on whether or not there were state failures?
Well, the Secretary of State, there were state failures in this. There were arguable state failures. So the point that the Secretary of State, for the Secretary of State, is to consider what impact, if any, do these have on the decision to deprive? How do they affect the decision to deprive? Because in a situation where the state failures were effectively to put her into the very situation for which she's being deprived, is it right in those circumstances to deprive her? Does the state bear some responsibility for her being in the very situation in Syria, which is the basis of her being deprived? And if the Secretary of State had asked all of those questions and had considered whether or not, having taken into account all of the legal obligations and the impact on the decision, the impact of those obligations, and whether or not deprivation represented an impediment to the fulfilment of those obligations, if the Secretary of State had considered all of that but nevertheless concluded, well, in this instance, we've looked at all of this and what we're required to do. We've considered all of the state failures and what we might be required to do legally. But nevertheless, the national security case is so overwhelming that it outweighs all of that, then that may have been a lawful decision. But because none of those were considered in this case, the decision, we say, was unlawful.
Can I just put one thing to you, the devil's advocate for a moment? The submission to the Secretary of State described in quite eloquent terms that she could be regarded as a victim. I think first and foremost a victim, and it's probably abbreviating slightly, but to say a victim of, let's say, manipulation by older people who were seeking to encourage her to go and travel to the caliphate. But you say there's a difference between being a victim of manipulation in the broader sense and being a victim of trafficking for sexual exploitation.
Absolutely, the victim.
But I think there was also quite a lot of stuff in the public domain. I can't remember whether it's referred to in the submission. Quite close to the time of her departure, let alone the deprivation decision, about jihadi brides and all that. So couldn't it be said that those advising the Secretary of State were well aware that one of the reasons why ISIS, ISIL, those groups seek to get women, sought to get women into the caliphate to be jihadi brides?
But that's our point about the significance of treating her as somebody where there's a credible suspicion that she was a victim of trafficking in the Article 4 sense, because simply saying, well, I'm aware of jihadi brides and they're very dangerous, and I'm aware she might have been a victim of manipulation, but nevertheless she's very dangerous, goes nowhere near to fulfilling the obligations under Article 4. The point about her being sexually exploited, that's actually developed or in our skeleton below. It may be helpful just to have those paragraphs to mind where we set out our case. It's tab 4 of the supplementary bundle, and it's beginning at 62 and 63, referring to the problems of trafficking for sexual exploitation and primary targets about being child and female victims. The fact that there are special legal protections in place for child victims and that children cannot consent as a matter of law to be trafficked. There's then reference to the Department of Education guidance, domestic policy, and going over at 63, recognition that child sexual exploitation is never the victim's fault, and that all children and young people have a right to be safe and should be protected from harm. Many victims are only able to disclose after the provision of support, and then we come on to look at the legal definition in paragraph 64 of trafficking. And so it's absolutely critical to understand that it's not sufficient simply to say, for the minister to say, well, we're aware of the problem of jihadi brides, we're aware generally there's a problem. What you've actually got to do is, where there's a credible suspicion that an individual is a victim of trafficking, as there was in Ms. Begum's case, you then have to go on and consider the legal obligations that are owed to her, and that's what was not done. So the backdrop to this, the Secretary of State was well aware of, but they did not look at her as a victim of trafficking. And Mr. Larkin answered that very fairly, and he said, no, we didn't consider her as a victim of trafficking, and Article 4 wasn't considered because she was outside the jurisdiction. He was asked that specific question. Next point, if I may go on. Sir James's submissions on trafficking merged the Article 4 ground with the common law trafficking ground. We say it is important that these are considered separately because we're not saying that Article 4 requires national security and the risk she poses simply to be assessed through a lens of trafficking. What we're saying under our Article 4 ground is that the Secretary of State has to take account of its compliance with legal obligations owed to victims of trafficking as a factor weighing against deprivation, and balance the importance of complying with those against the Secretary of State's conclusions on national security. And we also say it's important not to merge the two because, of course, under Article 4 of the Convention, there's no rationality test. There's no suggestion of this, for example, in the case of VCL. In other words, if trafficking, and I think it was my lady's question earlier, if trafficking and legal obligations arising from Article 4 weren't properly considered, there is a breach of Article 4. You don't need to consider rationality or a so obviously material test. That's the common law prism, not the convention prism.
I might have missed a stitch, but is there a case on which you base the proposition that not to have regard to possible breach of Article 4 is in and of itself a breach of your obligations?
Well, we say it's in VCL paragraphs 160 to 162 that the decision in that case, prosecutorial decision, would have to take into account the assessment of trafficking. And the an article that was obviously an Article 4 case. It's also, you derive the same proposition from MS Pakistan and from EK, we say. Next, dealing with the jurisdiction arguments and the content of the duty. We say that if you ask the question, was Miss Begum in the jurisdiction at the time, within the UK, within the UK at the time of deprivation, that's the wrong question in this case. The two cases which Sir James took you to, HF and R3, arise in completely different situations. R3 was simply an Article 8 case, where the question was, is he within the jurisdiction of the UK for the purposes of Article 1? Answer, no, in that case. The Article 3 breach, the passages in HF, which Sir James took you to, the argument there was on the argument there by the appellants was premised on nationality or diplomatic assistance or operational capacity forming the basis for the territorial application of Article 1. That's obviously completely different to the situation we have here. We're arguing on the basis of the jurisdictional link, which has already been decided in the case of Ransef. And so there are, as I said yesterday, there are these two types, if you like, of cases where jurisdiction might arise as territorial cases and the sort of handful of exceptions to that. And then there are other cases where there's a jurisdictional link. And of course, in HF, albeit under a different article of the Convention, the Strasbourg Court goes on to look at whether there's a jurisdictional link. So it's a jurisdictional link type of situation that we're in here. And so in terms of the investigative duty, and they are separate, and we do say that a finding that there's been a breach of the Article 4, a failure to consider the Article 4 investigative duty is sufficient in this case to quash the decision. So in other words, the investigative duty is distinct from the operational duty. That is owed irrespective of whether somebody is in the jurisdiction.
Can you tell me what you mean by the word consider?
So the Secretary of State should have, when taking the decision to deprive, have recognised that it had a duty to investigate the situation of trafficking. Sir James argues for a very narrow concept of the duty to investigate, one that's essentially looking at finding perpetrators and criminally punishing. But the domestic law, which I took the court to yesterday, the case of Amin and AM, decision of Lord Justice Sedley, make it very clear that the purpose of investigation is wider. It's not simply about tracking people down to punish them, but it's also about learning lessons. It's about identifying and finding facts in relation to state failures. So it's not just victim focused, in other words, as Sir James suggested. It's a wider purpose, and it seems clear to us that Ms. Begum would need to participate in that investigation in order for it to be full and effective and to satisfy the Article 4 duty. She obviously can't participate from the camps, and so the Secretary of State, when asking himself or herself the question about whether or not there can be compliance with that investigative duty, needs to consider whether the decision to deprive effectively frustrates the duty. Of course, it's accepted that they may be able to investigate some aspects, but the question is whether the decision to deprive, which would effectively prevent her from participating, from them asking her questions about what happened, who groomed her, who recruited her, what persuaded her, that's not possible because of the decision to deprive. And we say, of course, it was open to the Secretary of State to conclude that the national security concerns in this case were such that it would be proportionate to comply with the investigative duty without her participation. In other words, she could stay there, but it had to be considered as part of the decision to deprive. And Sir James takes issue in his submissions with connecting this obligation, this Article 4 investigative obligation, into the Section 40 duty. But we say that's simply just an incorrect analysis of MS Pakistan. So it was said in answer to the question from the court this morning, what's the difference between removal and repatriation? But the distinction, the correct distinction in our submission is it's an analogous situation, a decision to remove and a decision to deprive, because it's the decision that we're looking at. In both cases, the Secretary of State is taking a decision which affects the individual. In MS Pakistan, there was a breach of the Article 4 duty on the facts of that particular case. And so MS Pakistan is on all fours, and we're in an analogous situation. We have a decision to deprive, and that decision needs to be taken compatibly with Article 4, and the question of whether the duty to investigate can be fulfilled needs to be considered by the Secretary of State. Then, in terms of the recovery obligations, we say there are two ways of looking at the recovery obligations. First of all, as part of the operational duty, which was triggered whilst Ms. Begum was in the jurisdiction, has not been discharged and was not extinguished on her leaving the UK. And we say it's not enough for the Secretary of State to say, as she does, that she's outside the jurisdiction, we've no longer got any recovery obligations towards her. The link arises because she had a pre-existing right not to be trafficked while she was in the UK. She had recovery obligations which were triggered while she was in the UK, and they were not discharged. So it needs to be considered, the Secretary of State needed to consider at the date of taking the decision to deprive whether a compliance with the recovery obligations would be frustrated or impeded by deprivation, and if so, whether it could be justified. And if you're not with us on this argument, the separate argument is the recovery duties which form part of the restitutionary obligation. It's said against us that we can't rely on this because there is no actual breach. We completely accept that the principle itself arises if there is an actual breach. But our point is that the Secretary of State had to consider whether there had been a breach, and if so, what obligations arose under the restitutionary obligation. It's not good enough for the Secretary of State to simply say, well, we don't know whether there was a breach, and there's no finding made by SIAC. They were under an investigative obligation to establish the facts, and they failed to comply. And so we say they can't simply dismiss the restitutionary breach on the basis that SIAC didn't make a finding of an actual breach, in this case of state failure.
Do you say SIAC should have made that finding?
SIAC didn't need, well, I think we're at IDEM. SIAC, it wasn't for SIAC to make that final finding, it's for the Secretary of State ultimately to consider whether there have been state failures. SIAC needed...
In your case, what SIAC said, which was there was a possibility of state failure, is a sufficient basis, you say, for the Secretary of State to notice that has all to be built into analysis of the
to be
deprivation.
considered, yes, absolutely. It's sufficient for the purposes of our argument. And
Sorry,
then
we got this the wrong way around. You say they should have investigated sufficiently to find out whether there was actually a
State
breach of
failure.
the protective duty. Had been a breach of the protective duty in 2015. They is the Home Office, not they.
no, exactly.
SIAC come later.
Yes, it wasn't. It's the state to investigate the facts of the trafficking, and for the state to investigate under Article 4 the state failure as part of that AM, and so for the purposes of our case, it's sufficient that SIAC found there was an arguable breach. Sorry, that there was arguable state failure. There were on the facts of the case, the finding was hardly surprising that the facts in relation to the failings by the police and by the school were clear. But the SIAC, for the purposes of our argument, we don't need any more than SIAC's finding, because it was for the Secretary of State to consider that as under the rubric of the Article 4 obligations arising under the operational duty and recovery duties and restitutionary duties. They needed to consider all of these things at the date of the decision, in light of the fact that there was clear evidence of potential state failure.
So more reply points. What's the next point from Sir James that you want to reply to?
And just two very short points. First of all, we don't accept that our case has changed. We always made it clear that the obligations are not absolute and were not a complete bar to deprivation, and we've always accepted that they can be outweighed by national security concerns, and the paragraphs in our skeleton below, paragraphs 4, 54 to 55 and 1 to 7. And in relation to the point about non-punishment, finally, so I give my learned friend Mr. Squire's time. What is required is an indication that Strasbourg will travel there. That's what you get from the authorities, AB and ULA, and we rely in particular on VCL paragraph 159, and the need to consider whether the appellants were victims of trafficking and consider non-punishment in the context of the recovery obligation before taking the decision.
Well, Sir James said you needed to have a finding that you were a victim in order for there to be, for the non-punishment principle to be engaged. What do you say to that?
So no, because the non-punishment principle forms part of the Article 4 obligation. As with our arguments, the credible suspicion is sufficient for the purposes of that to be triggered, and the Secretary of State obviously has to consider, as part of that, given that they are dealing with somebody they know to be a potential victim of trafficking, has to consider whether the imposition of deprivation is effectively a penalty, which would be contrary to Article 4. Those are my replies.
Thank you very much indeed, Ms Knights. Yes, Mr Squire.
My Lady Laws, I'm going to do my best to try and reply in the time. Is there any prospect you might be able to hear me partly on this
I think
tomorrow?
if we're talking about a fair division of time, your side has had significantly longer than Sir James has, but we're not going to stop you at 4:15 on the dot, but do your best, please.
I'll do my best. But the two respondents' notice points are quite large and important points, which I will do as quickly as I can. But, so starting with that, the question is this. Has Parliament, by necessary implication, abrogated what's described by Lord Newburgh as the rule that before a statutory power is exercised, any person who foreseeably would be significantly detrimentally affected by the exercise should be given the opportunity to make representations.
There's procedural fairness.
Procedural fairness. Yeah, I apologise. This is the respondent's notice point, procedural fairness.
Understood, thank you.
Is there a right to make representations here? And the question is, has it been removed by Parliament? It's not said clearly that it's been removed expressly by Parliament. What is said is it's been removed by necessary implication by Parliament in section 45, which requires notice to be given of the decision and tells people they have a right to appeal. But what is critical here is this is an argument about statutory construction. And it may help to turn to the Morgan Grenfell case. You've got it, volume 1, tab 15, page 240, on what necessary implication means.
Reference again, please. Morgan Grenfell.
Morgan Grenfell, volume 1, tab 15, page 240. And it's paragraph 45, which is at 293.
Paragraph
45. Because what Sir James's submission is Parliament would have considered that ... how undesirable it would be, for example, Parliament intended to. These are the practical issues. That isn't the test. This is statutory construction, and it has to flow from, necessarily follows from the express provision of the statute as a matter of logic. Not what Parliament sensibly or reasonably included, etc. So what you have to decide...
So I don't get that from paragraph 45.
I got the wrong...
Look, you say
Oh,
it
sorry.
has to be
No,
a
maybe we do,
necess-
maybe we do,
has to
we
be a
do.
necessary implication, not just a reasonable or
Yes,
possible
correct. And it's
implication. And you say-
And it's last sentence, it's logic is where you get it. It follows from the express provisions, not sensible, etc. So what you're doing is interpreting the words of section 45 and saying that it follows as a matter of logic that Parliament was intending to exclude the right to make representations. And Sir James was asked about section 43, which is the fraud cases, misrepresentation, etc. And this is why this ground is so important, because however you interpret section 45 will apply equally to all of those cases as well, because they're also governed, removal of citizenship for fraud, misrepresentation. So the conclusion of this court will be, if that is how you're interpreting this section, none of those people should be permitted to make representations before they are deprived. That is what you'll be saying Parliament has ruled, because section 45 those are Section 43 cases, 40 brackets 3. They're equally governed by Section 45. So whatever Parliament has done, it's done it for both. It's the same appeal structure. Again, you have a hearing.
Draconian power.
Same draconian power, precisely, my lady. It's the same power. So that's what you're interpreting. And it has to flow, I say, as a matter of logic, it would have to apply to the cases where people are within the UK in our context. And my Lord, Lord Justice Bean, noticed section 341 of SIAC's judgment, where it is said, often when people are outside the country, it will be difficult, if not impossible, certainly people who are not in detention. But the last sentence of that paragraph is key, because what SIAC also said is, yes, but, of course, this applies equally to people who are in the United Kingdom, and it's very hard to see a national security reason why that whole category of people would have been unable, Parliament would have decided to remove their ability to make representations, let alone fraud cases, misrep. So the argument is in fact a policy argument. This is the kind of thing Parliament should have done, but that isn't. It certainly doesn't flow as a matter of necessary implication from Parliament giving you a right to appeal, that Parliament intended to remove the right to make representation. And I think for that it is going to be important to turn up, again, very briefly, the Bank Mellat case, because the bit that's quoted in Al Jeddah misses out some critical paragraphs. So again, if you have that, volume 2, tab 28, volume 1, so it's the last one in volume 1.
I asked Sir James and he said somebody would look it up, but I don't know whether you know the answer, whether the new subsection 5 capital A of section 40 was in existence at the time of Al Jeddah decision, because it does seem to me rather to change it, that Al Jeddah doesn't mention it, but now Secretary of State doesn't have to give notice if the Secretary of State reasonably consider it in the interest of national security not to give notice.
No, that wouldn't have been enforced. I think that comes, in case my lady will be aware of, D4. It followed a case last year. So it wouldn't have been in place.
Oh, I see. It's as recent as that.
Yes. There was a statute change following the Court of Appeal's decision in D4.
Right, thank you.
So May 2023, I've been told.
Thank you very much.
It's very recent.
Right, sorry, you were...
Followed that. Yes, so Bank Mellat, 3 key paragraphs in Lord Newburgh's judgment, 178 and 179. If the court can glance down those two. This is the general rule that Lord Newberger cites, 179, can be abrogated, he says 179, but then 191, abrogation, middle of 191, the right is so important that the implication must be very clear that Parliament is abrogating the right to make prior representations. Lord Sumption, 28, general principle of the importance of representations, old provision of what we now call the public law, and then 35, and this is, when one goes to the Al Jeddah judgment, it does go through 35, 37, but it misses out a key quote, which is the end of paragraph 35. Like Lord Bingham in West, I find it hard to envisage a case in which the maximum expressio unius exclusio altus would suffice to exclude a basic right as procedural fairness. But that is precisely the argument the Secretary of State has to make here, because that rule applies. It's if you've done something procedural, given a right to see a notice, given a right of appeal, by doing something, you've excluded procedural fairness. That would have to be, that is the consequence, that is his argument, it has to be. 45 says, we'll give you notice, you can have an appeal. That is the operation of that maxim. And as I say, that Al-Jeddah didn't refer to that, it didn't quote that bit of the judgment, it's not quite clear why. But that is what he is inviting the court to do. And moreover, doing it, we say, in a way the statute simply doesn't permit. You do not get from the logic of a statute that says you can appeal, we're going to take away something as fundamental as the right to prior representations. We then made various submissions about, well, it's not a judicial review when you get to SIAC. Well, correct, SIAC dealt with that, 335 to 337. What it said, we must consider the substance, not the taxonomy, which we respectfully endorse. And the key point is that whatever SIAC can and can't do, that you can't do on a judicial review, what it absolutely cannot do, we've seen, is enter into any discussion, consideration on the merits. So your one opportunity before you are something as devastating as deprivation to influence the merits of the decision is before the Secretary of State before. And so again, that reiterates the importance.
Sorry, what do you mean SIAC can't entertain the merits?
You can't come to SIAC and say, look, you've assessed national security wrong.
Right, I see.
You can't come to SIAC and say, you've got the balance between various different things wrong. So that's why it's entirely critical that you are able to do so before, and there is absolutely nothing that suggests Parliament, certainly as required by Morgan Grenfell, has removed that. So I say, a very, very big point which I've tried to deal with, but I say because it matters, because it's not just, it's all of the Section 40 deprivations that this would apply to. I say the Secretary of State practice is, in fraud case, entirely understandably to say, before we deprive you, have you got anything to say? But that would have been precluded by Parliament on Sir James's. Parliament would have said, no, can't do that. Simplex, it was said to be, we haven't identified any error of principle in Simplex. Not correct. The key error of principle, we say, is if you go back to SIAC's judgment, page supplementary bundle 161, paragraph 346. Whole bundle, apologies. I heard some mumbling there, I thought I got wrong. 346. It's 346, 347, 348, 349, and the critical error is the limitation on what it is said would have been put on Ms. Begum's behalf, and I'll come to why that's an error of principle. We accept they wouldn't have had to wait many months and for all of the evidence that was presented to SIAC, but the question is, what could have been done in the 14 days? And what SIAC has to conclude, and this is where the test is wrong, it has to conclude it was inevitable that all that could be said on her behalf was, well, she was a child at the time, might have been radicalised, 349. That's the burden at the simplex stage. There's no suggestion, and there'll be no possible basis for saying it's inevitable. That's all she would have said. That's why you do have to look at the range of
I
possibilities.
thought it was inevitable that would have been the outcome, not inevitable that was all that could have been said.
But it must be the same test, because if you're saying,
Right.
well, we will assume, because otherwise what you're saying is, on the balance of probability, she probably wouldn't have said this. But that can't be the right, the test ultimately is it inevitable? Had she been given this opportunity? And that must be the same test for what she would have said. Otherwise you're saying, well, and it's not even clear what standard they apply when they say, well, that's all she would have said. Or we would say, in any event, it's impossible to see why she wouldn't have said state failure, etc., etc. Groomed, sexually exploited, state failure. This is you failed this girl, in essence. But to say it's inevitable she wouldn't have said that, which we do, we respect to say that is the correct test. So James said, well, it's not a rationality test. Decision maker couldn't have done anything different. We say, respect, it must be. That must be what inevitable means in this context. A rational decision maker could not have done something differently. Otherwise, it's not inevitable. It's simply the logic of the language. He next said, well, what SIAC does, it puts itself in the boots of the decision maker. And we say, respect, that's wrong. That's exactly what Cotton and the Planet B case we cited in our skeleton say you do not do. You don't put yourself in the shoes of the decision maker precisely because then you're undertaking a merits review. And you can see that his next submission was, well, you have to give respect to the Secretary of State's national security case. But of course, what SIAC's doing at this stage is balancing, working out how the Secretary of State would have balanced a rational Secretary of State, we failed this girl, against national security. And we do respectfully say that is simply outside SIAC's competence. It can't, that simply can't, that is a quintessentially something for the executive. It was then said, well, all of these matters were, the evidence before SIAC, which SIAC can consider as well, these matters were considered by later security assessments. Therefore, that goes to show, and they've dealt with them. But of course, firstly, that doesn't deal with the argument about state failure, because that's never been considered at any stage. So we have no idea what the Secretary of State would have done had he considered that. But even on the trafficking evidence, if you like, all of the expert reports. So James said, look at page 815, supplementary bundle. This is ONS 2, paragraph 5 to 7. He says, look, dealing with that evidence, but he didn't take you to it. If you can just turn it up, page 815. You will see that paragraphs 5 to 7, if you just glance down it, is in fact only dealing with responding to one of the national security, the appellant statements, one by Mr. Barrett and Jordan, but they're not trafficking experts in the sense that we were relying on trafficking experts. They are, in a sense, national security. I think Mr. Barrett is a very sort of senior. Mr. Barrett was a former director of global security at MI6. That's the only one of the statements they deal with. We don't know. They haven't explained why they don't accept what Dr. Korzynski said about voluntariness, why people stay with their traffickers. All we know is the Secretary of State hasn't changed his mind and is still contesting the appeal. But of course, that doesn't help at all at Simplex, because in every single Simplex case, by definition, by the time you've got to court, the Secretary of State is still resisting the case. So what was meant by Lord Justice Sales, as he then was in Harvey, by evidence or submissions, is an explanation of why, had you taken these matters into account, you still would have reached the same conclusion. That we simply don't know, because they haven't dealt with the state failure at all. And national security, the only statement they respond to, certainly in 5 to 7, and I'm pretty sure it's the same in all this statement, is Barrett and Jordan. That is Simplex. Moving on to public sector equality duty. The first submission that was made by Sir James was seeking to rely on Maroof to say essentially, well, these are about challenges to policy decisions, not challenges brought in individual cases. And I'm afraid here I am going to take a pleadings point, because SIAC dealt with this point. Paragraph, it's page 169, oh sorry, paragraph, I think it's right. Page 169, paragraph 395. and rejected it. And we don't have respondents' notice. I made submissions on this to SIAC. I can obviously make them again, but that isn't an issue that's before you. It can apply to individual decisions. And of course, by definition, section 1491C, which is fostering good relations, by definition applies to other people. That's the whole point of that provision. Of course, you have to have due regard to the need to foster good relations. This is, what's this going to do in the wider community across the country? By definition, that is not about the individual affected in any case. It was then, my own friend then went on to extraterritoriality. Again, I will. Again, quite a large point, which I'll try and do very quickly. He said that, correctly, Maruf Tehrani concerned with Palestinian individuals being able to access a particular scheme in Lebanon and Syria. And he said, oh, well, at least he appeared to say, well, that might affect Palestinians in the UK, but that isn't what the case was about at all. No one suggested that. In fact, it wasn't a 1491C case at all, which is the community relations. It was 1491B, which is about equality of opportunity, and it was entirely about equality of opportunity of Palestinians in Syria, Lebanon. And it is important to see what the court held and what the extraterritorial issue was in that case. Going to the Court of Appeal judgment, and I will go very briefly to the Supreme Court as well, I'll give you the references, tab 50, page 1551. I'm going to say the Supreme Court essentially agreed with Lady Justice similar as she then was. So volume 2, volume 2, tab 50 is the Court of Appeal. And the key paragraphs are 100 to 104. And in fact, Lord Justice Underhill 109 agrees with Lady Justice Simler's analysis. And again, I won't take you through all of that now, but the key point about this, or the key decision was, what you don't have to do is to have due regard promoting equality or fostering good relations in respect of persons and matters outside the United Kingdom, which is the middle of 100, 102, which we'll see is specifically approved by the Supreme Court. Parliament wouldn't have asked for consideration of things outside the United Kingdom for all those reasons. And 103, again, explains why that will be incoherent. Similar conclusion. Oh no, sorry, I gave you the right. It was Lord Justice Underhill was 112 agreeing. A similar conclusion. Lord Justice Underhill 112. You're not quite to consider people outside the United Kingdom. And Maalouf, Supreme Court, essentially agrees, quotes Lady Justice Simler 52 and adopts essentially the same analysis, 53 to 56. And this is a point of statutory construction, extraterritoriality. And it may be helped just to turn up section 149. It may be very familiar. It's at page 9, volume 1, tab 3. And what it says, we can 1491B, 1491C, so this was 1491B case, ours 1491C, is that what you're concerned with, you need to have regard to the need to advance equality opportunity between persons who share relevant protected characteristics, persons who don't, good relationships between persons who share, foster good relations between persons. And the issue of statutory construction in Maruf Tarani was that word persons, where are those persons located? That was the issue of statutory construction. And what they said is, Parliament didn't intend that to be extraterritorial, normal rules apply, the only persons interpreting that word, and the only good relations you have to consider are persons in the UK, good relations in the UK.
I'm speaking for myself, Mr. Squires, I think you're right about that, but what do you say about section 192?
Coming on, I can come on to that.
I'm going to.
Yes,
we
yes.
are going to have to rise 4:30.
Yes,
So
right. Section 192. Yes, no more on that. Section 192. It was said, following the question that Justice Whipple asked me, you've got to read something into section 192 if our analysis is correct. But the position is you have to read something into section 192 under any analysis, because proportionality necessarily entails a harm against which you are balancing something. So that is the consequence of Parliament drafting in this way. And when my learned friend was pushed about that, he said, well, what about things like less intrusive means? But the whole point about less intrusive means, what that means is some less intrusive harm. So you have to have something on the other side of the balance. Parliament could have legislated this section, as I think the court noted, by simply saying Secretary of State says national security, but it could have also done it, Secretary of State, or sorry, a person does not convene this act only by doing something they reasonably consider necessary for national security. Then it would be effectively a rationality test. The person comes along, they say, I did reasonably consider it, you want to challenge that, it's rationality. But Parliament's used the word proportionality, which must require a balance between some form of harm, interest, interference, and the good on the other side. So you've got to read something into this section, and the Secretary of State and SIAC's analysis is entirely unclear what you read. What is the harm, if you're talking about a less intrusive analysis, what is the harm that you are thinking about? And we say it would have, it then suddenly becomes incoherent, harm to Ms. Begum, her family, the Muslim community, etc., etc. And the other fundamental difficulty with all of this is this, which Wellington didn't respond to, is that, of course, SIAC didn't undertake this analysis because proportionality isn't an issue in a deprivation case under Article 8, and it's paragraph 403, not an issue under common law, paragraph 69. So the consequence of the Secretary of State and SIAC's interpretation is that when you have some discrimination, that then opens a gateway to an entirely freestanding proportionality exercise, untethered to anything in particular, which in fact you don't have, and SIAC didn't conduct, in a deprivation case. And we say that that can't be right. And as I said, if it is right, SIAC didn't do it.
right, de facto statelessness.
And yep, de facto statelessness.
You've made written submissions, full submissions first time round. Anything to respond to?
Yes, two very short points. It was said we accepted that the ministerial risk statement had said she could not go to Bangladesh. That isn't what it said. What it said is her repatriation to Bangladesh is not a direct and foreseeable consequence of her losing her British citizenship. Say, entirely unsurprising, but saying something entirely different. Yes, it won't be a consequence. She's not going to be put on a plane as a direct consequence of losing her British citizenship to Bangladesh. So we do say that isn't what it said. And secondly, it said material consideration. It is said it doesn't matter what label you put on it. We agree. Doesn't matter, but so long as you do give it, you have considered it. We agree. But it's what the material consideration is. It's a factor militating against deprivation. So considering this, which it was considered as a factor in favour of, doesn't matter, it's not the label, it's the substance. That is the basis on which it was considered. And that cannot conceivably be satisfying a material relevant consideration, which has to be, this is the harm it's going to cause her. That's not what was done. This was considered as a, well, this is a reason why I can deprive her. It had to be considered, this is the harm, I'm balancing it against national security. I think I've hit, I'll
Well
turn
done.
round, but I have it.
Well done, Mr. Squires. Yes, Mr.
Sorry, while he's turning round, one authority that wasn't referred to in opening, can I just give you one reference? It's in response to the Morgan Grenfell citation about necessary implication and what that means. You need to know that there is a subsequent Supreme Court authority that directly considers the meaning of necessary implication and introduces it as a broader issue of statutory interpretation where you're seeking to discover and trade the purpose of Parliament. So, slightly looser approach. The references to the Queen brackets Black and the Secretary of State for Justice 2018 appeal cases 215, and the relevant paragraph which contains all of the summary of principles is paragraph 36.
Thank you. And Mr. Squires, if you need to respond to that, you can do it on one page by 10:30 tomorrow morning, if that's all right. I hope you get some sleep. Ms. Knights, Mr. Squires and the rest of the appellant's team, thank you very much for your very helpful submissions. I think it's time to say a fond farewell for the time being. We will, of course, through the special advocates, make sure that if it turns out there's anything we can involve you in properly tomorrow, that will take place. But at the moment, the plan is for the entire day to be enclosed. We anticipate we will be reserving both open and closed judgments, and we will be providing you with details, the hand down, in the normal way nearer the time when we've worked out quite what procedures we're going to be adopting. Anything else that either of you would like to add at this stage? I know it's been very much a team effort, so thank you to everybody who's been involved, and we look forward to seeing everybody else tomorrow morning at 10:30. Anything else, David? No. Thank you very much indeed.